Next, reaction from Capitol Hill on the Supreme Court decision. Senate Judiciary Chairman Arlen Specter talks about legislation he'll be offering on the military tribunals. His remarks are about 20 minutes.
The senator from Pennsylvania is recognized.
Mr. President, I have sought recognition to discuss the case of Hamdan versus Rumsfeld, which was decided by the Supreme Court of the United States today, and to address the question as to where we go from here. There have already been many inquiries as to what is the import of this Supreme Court decision and what are the next steps in order to establish a framework to deal with the people who are detained at Guantanamo Bay. Since the opinions were released this morning, my staff and I have been reviewing them, 177 pages, 6 opinions. The essence of the decision of the Supreme Court of the United States on a 6-3 vote is that the President did not have the authority to establish the military commissions, and that the authority rests with the Congress under the Constitution. The court dealt with the issue of the resolution authorizing the use of military force, a resolution which the administration has sought as authority for amending the Foreign Intelligence Surveillance Act. And when the court dealt with the resolution authorizing the use of military force, the court said that that did not give the President the authority to establish the military commissions. The court did not deal with any issue of inherent authority, but obvious from the decision that the President lacked the authority to establish the military commissions is the conclusion that there is no inherent authority, an inference and a proposition which may have some weight as we consider collateral matters, for example, on the electronic surveillance under NSA. The Constitution of the United States is explicit in Article 1, Section 8, which states, and I'm leaving out some of the irrelevant language, Congress has the authority, quote, to make rules concerning captures on land and water. So it is a congressional matter. In reaching its conclusion, the Supreme Court of the United States found that the military commissions violated the Code of Military Justice and also violated the terms of the Geneva Convention. The court found that the military commissions violated the Code of Military Justice because they did not provide for very basic due process considerations. The court said that the military commissions violated the Geneva Conventions, which the court found applicable, reversing the Court of Appeals for the District of Columbia, where the Supreme Court said the Geneva Convention, Common Article 3, plainly affords some minimal protection to individuals associated with neither a signatory nor even a non-signatory who are involved in a conflict. The court dealt with the issue of jurisdiction by saying that the government contention that the Supreme Court had no jurisdiction was wrong. The Supreme Court referred to the provision of the Detainee Treatment Act of 2005, which provides, quote, no court shall have jurisdiction to hear or consider an application for habeas corpus filed by an alien detained at Guantanamo Bay, was a reference to the statutory provision which gave exclusive jurisdiction according to the statute to the District of Columbia Court. The statute provided specifically the United States Court of Appeals for the District of Columbia Circuit shall have exclusive jurisdiction to determine the validity of any final decision of a combatant status review tribunal that an alien is properly detained as an enemy combatant. I argued as forcefully as I could when that amendment was considered that it was searching for the right word. It was really atrocious, without any hearings, without any extended floor debate. And I had 2 minutes to speak under the rules of governing the amendment that we would be taking away jurisdiction of the federal courts except for the District of Columbia. Now, on its face, that language would say that the Supreme Court of the United States had no jurisdiction. Well, the Supreme Court made short shrift of that point, saying that it did have jurisdiction. When you deal with a constitutional issue, it is hard for this lawyer to understand how you can take away jurisdiction from the Supreme Court of the United States. How can you do that when we know since Marbury versus Madison in 1803 that the Supreme Court of the United States is the final arbiter of the Constitution? But this language, this clumsy language, sought to vest exclusive jurisdiction in the Court of Appeals for the District of Columbia. Well, the Supreme Court made short shrift of that. But on a personal note, and relevant to this consideration as well, in Justice Scalia's dissent, he cites my floor argument in a footnote saying, quote, at page 12 of his opinion, quote, an earlier part of the amendment provides that no court, justice, or judge shall have jurisdiction to consider the application for writ of habeas corpus. Under the language of exclusive jurisdiction of the D.C. Circuit, the U.S. Supreme Court would not have jurisdiction to hear the Hamdam case. It at Senate Congressional Record 12796, parenthesis, statement of Senator Specter, close parenthesis. Interesting that Justice Scalia, who doesn't believe in congressional intent or congressional deliberation, would make that citation. But when I made that point, that the statute on its face took away jurisdiction from the Supreme Court of the United States, I made it plain that I did not think it had any validity. Couldn't do that. What the statute really was trying to do, in part, was to look to a favorable court. The D.C. Circuit was a favorable court, a little court shop, and there was an effort to take away the jurisdiction of the district court from habeas corpus proceedings. Well, under the logic of Hamdan, where you have a statutory provision that the D.C. Circuit has sole jurisdiction, the Supreme Court reads that and not to take away jurisdiction of the Supreme Court. Inferentially, the same conclusion would follow for the district court. It doesn't say the district court doesn't have jurisdiction, just like it doesn't say the Supreme Court doesn't have jurisdiction. It just says exclusive jurisdiction is in the D.C. Circuit. A little hard to see how that would work out if you file a petition for writ of habeas corpus in the D.C. Circuit. It would be anomalous. Those petitions are filed in the district court. But at any rate, the Supreme Court of the United States took jurisdiction of the case and found that the procedures which the administration has prescribed do not comport with law. The Judiciary Committee held a hearing on Guantanamo and made a field trip there. A number of us, including myself, went to take a look at Guantanamo, to see it firsthand and to question people there. I had gone there with the expectation of having a field hearing there. I wanted to hear from the officials at Guantanamo. And when I got to Guantanamo after the flight in, I was told there would be no field hearing, which was a disappointment and really contrary to what I'd understood the arrangement to be. But we held the hearing and have devoted a considerable amount of work to the issue, knowing that, or thinking that the administration's military commissions would be struck down because they did so little, had no real relationship to due process, and we've prepared legislation. I had it put in final form last week when we considered the Department of Defense authorization bill, and one senator did talk about legislation, and I considered offering it at that time, but decided that it was not a good time to do so. But we have it ready to go, ready for introduction. Senator Durbin and I introduced a bill to handle the Guantanamo detainees on February 13th, 2002. And the issue was not picked up again until the Judiciary Committee held hearings last June. And this bill, which I'm introducing today, and I would ask the court reporter to strike the notation on the top of each page, discussion draft. It is not a discussion draft. It is a bill which I'm introducing. I believe will satisfy the requirements of the Supreme Court of the United States. This bill provides for two divisions. One is for the people who are charged with specific offenses, and we retained the caption of a military commission. We provide that there would be 3 officers on the commission, 1 president judge presiding from the Judge Advocate General's office. An attorney will be provided for the accused. There would be competent evidence. There would be cross-examination, be a unanimous verdict. In the event of classified information, we prescribe that the provisions of the Confidential Information Protection Act would govern, which is a statute which has been used in our courts for many years, which authorizes the presiding judge to sift through the information, make available to the defense whatever is appropriate and not classified, and if it is classified, then to make it available at the discretion of the judge to the attorney. The attorney for the accused would be cleared through regular channels to deal with classified information, so that we would be protecting the classified information by having it viewed only by someone authorized to take a look at it, and having the maximum exposure practical so that the defense lawyer would be able to use it in the defense of his client. Not a perfect situation, but that's the way we have dealt with confidential information under the so-called CIPA, Confidential Information Protection Act. In our legislation, we also deal with the enemy combatants. These are the individuals who have been detained at Guantanamo under an arrangement where there is no limit as to the length of their detention. And that has caused considerable angst, considerable objection, but it is a very difficult matter. And when we are in a war fighting terrorists, and we should never lose our focus that we are in that war and that there are continuing dangers, and we have to protect Americans, that until somebody has a better idea, they're going to be detained. Some have been released, and some of those released have been found on the battlefields killing Americans. So that the detention of enemy combatants is an ongoing problem. Our legislation provides that there would be a classification tribunal so that there would be a review of their status to make a determination on a periodic basis that they continue to be a threat to the United States, to be a threat either to us in the continent or a threat to go back and fight a war. We provide for an attorney, again, an attorney who would be cleared for classified information. The issue of evidence is a much more difficult one because these enemy combatants are frequently taken into custody on a battlefield situation where competent evidence is not present. So we allow for hearsay. In the Supreme Court opinion, there is leeway granted to have sufficient due process on a showing of necessity. The Supreme Court found, for example, that the President had demonstrated sufficiently that there could not be trials in the United States federal district courts, so that ruling that out was fine, was acceptable. And leeway, too, for some deviation from all of the generalized rules might be acceptable. They didn't really reach it because they didn't have a specific situation. But there'd have to be a showing of necessity, a showing that no other system would work. So in dealing with the enemy combatants, we're still struggling as to how to handle it. On the issue of indefinite detention, recognizing that they continue to be a threat. The legislation which I'm introducing today has received considerable thought and considerable analysis. And as I say, it picks up on legislation which Senator Durbin and I introduced on February 13, 2002. But it still requires a great deal more analysis and a great deal more thought, which we will give it in due course on the legislative process. We have altered our schedule in the Judiciary Committee to reserve July 11th for a hearing. Second day we're back, first day we come back on a Tuesday and really swing into action, where we will take up an analysis of Hamdan versus Rumsfeld in greater detail than we could do here this afternoon in a short floor statement, and with only a few hours to digest 6 opinions and 177 pages. And we will consider this legislation at that time. I ask unanimous consent that the full text of the bill be printed in the Congressional Record at the conclusion of my comments, and a short summary of the bill which will enable the reader to follow it without going through the extended text.
Without objection.
I thank the chair. I thank my distinguished colleague from West Virginia for waiting. I know he has an important speech to give. I just conferred with the senator from West Virginia, and it's his 4th of July speech. It's a little early for the 4th, but there may not be too many people in the chamber on the 4th or the 3rd or the 2nd or the 1st or even tomorrow, the 30th of June. So I compliment Senator Byrd in advance and yield the floor.